Chapter 12. Negligence. Negligence is the failure to act with the level of care that a reasonable person would have exercised under the same circumstances. The tort of negligence allows a victim to recover for harm that the defendant did not intend to cause, but was caused by accident. There are 4 elements that make up the prima facie case for negligence. They are duty, breach, causation, and damages. Each element must be proved in order for the plaintiff to recover under negligence. Let's briefly discuss the 4 elements, and we will go into more detail in the following chapters. 1. Duty. To recover under a theory of negligence, the plaintiff must show that the defendant owed a duty to the plaintiff. In our society, everyone has a duty to conduct themselves as a reasonable person would under similar circumstances. Note that in certain cases, the level of care that is owed will vary depending on the circumstances or the relationship between the plaintiff and defendant. 2. Breach. Once a duty of care has been established, the plaintiff must show that the defendant has breached the duty. Note that a breach may consist of either an act or an omission to act when there is a duty to do so. 3. Causation. In determining cause, the plaintiff must show that the defendant's act was the actual and proximate cause of the harm. This means that the breach must have actually caused the plaintiff's injury, and also that the harm was a foreseeable result of the breach. 4. Damages. Lastly, the plaintiff must show that he has been injured as a result of the defendant's breach. If the plaintiff does not suffer harm, he cannot recover for negligence. Note that if a plaintiff successfully proves all 4 elements and makes a prima facie case for negligence, the lawsuit still may be dismissed because there are several defenses to negligence. The first element of negligence is duty. In our society, everyone has a duty to behave like a reasonable person. However, the reasonable person's standard of care will vary from case to case. For example, Jen is driving on a country dirt road in the middle of nowhere. She accidentally runs a stop sign and hits Billy Bob. In this case, Jen had a duty to drive as a reasonable person would drive, which entails paying attention and obeying traffic laws. Let's instead assume that Jen is driving through a school zone crowded with students and accidentally runs a stop sign and hits a schoolgirl. In this case, Jen will be held to a higher standard because the level of care that is required when driving through a school zone is much higher than when driving on an empty country road. Let's move on. In the majority of jurisdictions, a defendant owes a duty of care only to foreseeable victims. This is Justice Cardozo's zone of danger rule from the landmark tort case Palsgraf v. Long Island Railroad Company. In this case, a train employee dropped a small package which happened to contain fireworks. There was an explosion which caused heavy scales all the way at the other end of the platform to fall and injure the plaintiff. Justice Cardozo, writing for the majority, held that a defendant owes a duty only to foreseeable victims, and since it was unlikely that the plaintiff would be harmed by the dropped package, she was outside the foreseeable zone of danger and she could not recover. Note that a minority of jurisdictions followed Justice Andrews' dissent from Palsgraf, which held that a duty of care is owed to everyone, even those who are not reasonably foreseeable victims. Moving on, note that a defendant owes a duty not only to foreseeable victims, but also to anyone who goes to the rescue of a victim. Once a victim has been put in danger, it is foreseeable that someone would attempt to rescue the victim. Therefore, a defendant will be liable for any injuries caused by a rescue attempt unless the rescue attempt was unreasonable. However, a defendant is generally not liable when professional rescuers like firemen are injured coming to the aid of a victim in danger. Let's move on. In general, there is no affirmative duty to act. This means that a reasonable person is not under a duty to go to the aid of others who are in danger. For example, you are walking down the sidewalk at night and see a helpless man bleeding to death after being hit by a car. No one else is around. You walk by the stranger and do nothing to help him. In this case, you cannot be held liable because there is no legal duty to rescue a stranger in an emergency. However, there are 4 situations where an affirmative duty to act does exist. 1. When there is a special relationship between the parties, like between parent and child, between employer and employee, and between host and guest. 2. If the defendant voluntarily chooses to help a victim in danger, the defendant will then owe the victim a duty of reasonable care and, in most jurisdictions, must finish the rescue efforts. 3. The defendant will have a duty of rescue when the defendant was responsible for putting the plaintiff in danger in the first place. And 4. If the state has passed a law that requires people to assist others in certain emergency situations, then the defendant may have a statutory duty of rescue.